Captain Laurence Itumeleng Makgotloe has been arrested on case number 816 for 24 of 2026. The reports, the linkages, the intent, were the omissions a mistake or a plan?
So we do not focus on the quality, we focus on the quantity. And the whole reason why we focus on the quantity is not the correct thing, but is true. It's because of the number of cases we have.
How it started.
Yes, we are going to go back and rewind and recap the Madanga Commission testimony of Laurence Makgotloe. The testimony was very short and it was centered around his ballistic report on the Aman Swat KT Mlefe something case. Oh, before I go very far, on this recording, you're going to need your cup of coffee, tea. Rooibos is my favorite because we are going to be a little bit longer. So just grab something, grab a snack, anything. Let's go for it. So the ballistic report had 5 errors pretty much in it. So we're going to go through the errors one by one as we recap so we can understand this court case. Error number 1 is the 15 cartridge cases. Wrong paragraph reference. Makgotloe says the biggest issue involved paragraph 10.2 on his report. According to him, paragraph 4.9 referred to 15 AK-47 cartridge cases recovered in Bramley case, but 10.2 mistakenly referred to 3.4 instead. So paragraph 3.4 dealt with bullet cores rather than 15 cartridge cases. Why this matters? The report, as originally worded, failed to clearly state that the 15 AK-47 cartridge cases had been fired from the AK-47 rifle recovered in Bramley. Makgotloe says that was simply cross-referencing mistake. The state says that omission was hugely significant because those 15 cartridge cases were a critical part of connecting the Bramley firearm evidence to the Swat murder investigation. Going to the second error, the report did not clearly confirm the AK-47 link. Makgotloe admits that the senior prosecutor, Ronel Cortez, raised a query. The report did not clearly confirm whether the AK-47 recovered in Bramley had fired the AK-47 cartridge cases. He says he corrected it on October 2024. Why this matters? From a prosecutor's perspective, if the report does not clearly establish the ballistic link, it weakens the evidential chain and can create uncertainty when preparing charges or opposing bail. This is probably why the prosecutor reportedly warned that the report needed to be fixed for court purposes. Number 3 in this ballistic report. Wrong Bramley case murder. Makgotloe admits another mistake. He wrote case number 140. Instead, the correct case number is 149. Why this matters? This is less serious than the cartridge issue, of course. It is largely an administrative or typo error rather than an evidential error. However, it creates confusion about which docket is being referred to. Are we referring to docket number 140 or we are referring to 149? It can raise concerns about the reliability of the report. Error number 4 in this ballistic reporting. There were multiple versions of the report. According to witness A and B, Makgotloe openly acknowledged that he had a Word version, he had a PDF version, he had amended pages, he had replaced pages, he had multiple corrections over time. Why this matters? It became the prosecutor's major concern. Investigators apparently saw the several versions, amendments, page replacement, and changed commissioning dates, and they began to asking whether the report had been manipulated. Makgotloe says this was standard practice. Only corrected pages were replaced. Analysts did not normally recommission the whole report. Error number 5. Quality review found problems. The internal non-conformance review identified problems in the report. However, Commissioner Khumalo pointed out something important. The review only dealt with some errors, not all of them. It did not fully address all the issues that had risen over time. Makgotloe actually agreed with that criticism.
A very disturbing observation in the criminal justice system. It's a very, very disturbing observation. I know. I understand. I understand the background you give for the observation, but it doesn't change the fact that it's a very disturbing observation.
Now we fast forward. Makgotloe has been arrested. The charges are count 1, accessory after the fact to murder on the Amand Swart unaliving. Count 2, possession of unlicensed ammunition that they found at his house on a search and seizure. Count 3, accessory after the fact to murder on a murder for insurance where a wife was unalived. And we don't know what the names are. Maybe when the trial comes, we're going to know who these people are. Count 1 and 3 are equivalent to defeating and or obstruction of the administration of justice. So apparently those terms can be interchanged in this case. What I found very interesting is that the Madanga Commission record, the witness statements, the criminal dockets, bail hearing is cut and copy paste throughout. The same themes keep appearing, and you are going to see this as we get into the bail hearing. The state's theory is not that Captain Makgotloe committed the unalivings. Instead, the state alleges that he used his position as a senior SAPS ballistic analyst expert to deliberately interfere with murder investigations by producing misleading ballistic reports that protected suspects. The state says the ballistics were altered. According to the state, Makgotloe was assigned to the murder exhibit. He knew the investigators wanted comparison of the murder scene exhibits, comparison with the Bramley exhibits, identification of links to the other crimes. Yet his report omitted important exhibits, failed to analyze crucial rifle cartridges, contained distortions, failed to disclose firearm linkages. The investigating officer repeatedly describes these as deliberate distortions rather than innocent mistakes. And the investigation officer here is witness A and B. The missing 15 cartridges. The state places enormous emphasis on 15 spent AK-47 cartridges. These cartridges were recovered from a suspect linked to the SWAT murder investigation, were listed in the report, but allegedly they were never actually analyzed by Makgotloe. The state says omitting these cartridges undermined the entire ballistic comparison process. The state continues to say he delayed the investigation. Investigators complained that the ballistic reports were repeatedly delayed. Requests went unanswered. Senior officers had to intervene, and that senior officer apparently is none other than General Shibiri. The reports still came back incomplete. The state says this delayed a high-profile murder prosecution and created risks for the criminal case. This is how cases get to be struck off the roll, because if the courts are still waiting for the ballistics report that don't come, they'll just strike the case off the roll and let all these criminals back in the street. Independent experts found that what he didn't do. When the investigator, witness A and B, had lost confidence in Makgotloe, the exhibits were sent to Durban. Exhibits were sent to Port Elizabeth in Gqeberha. Independent analysts reviewed the same evidence. The state says Durban found links. Port Elizabeth, Gqeberha found the same links. The junior analyst succeeded where Makgotloe had allegedly failed, and he was a senior, more senior than them. This is one of the strongest pillars of the state in this case. The state continues to say the firearms linked to other murders. According to the state, the reanalysis linked the firearms to the unaliving of Afaman Swart, DJ Vini, DJ Somebody, and other high-profile murder investigations. The prosecution argues that these links should have been identified much earlier by Makgotloe. The investigators, witness A and B again, says he knew more than he should. One of the more unusual allegations is this: the investigators testified that before an eyepiece report existed, Makgotloe allegedly told witness A and B that the firearms were linked to other high-profile murders. The state argues, how did you know that? Where did that information come from? Did he obtain it from the suspects directly? The investigating officers openly suggest that this knowledge may have come from the people involved in these crimes. Oh, by the way, Captain Makgotloe had a search and seizure on the day that he was arrested at his house. So during the search, the investigators, now this is the CRTT investigators, found 43 rounds of state ammunition, one hollow point round, one shotgun round, 13 rifle rounds in an exhibit bag, 28 ballistic reports. This is another funny situation. The SWAT Brimley ballistic reports were found at his house. What? The APIS linkage reports, multiple case-related documents were found at his house. The state says many of these items should never have been stored at a private residence. Finally, this was a pattern. Prosecutor says the SWAT murder was not isolated. They allege the same type of omissions appeared in the 2018 murder for the insurance case. You remember count 3. This is count 3. Other ballistic reports reviewed during the investigation. The state's position is that investigators found a recurring pattern rather than a single mistake. Yo!
The procedure of the laboratory is every case file, once finalized, once you have done working on it, it goes to review. And almost out of 10 cases that goes to the review, 8 will be back with errors for correction, without any deliberate to do anything for any analyst who is working at the lab.
Defense version, on the other hand, says the lab was under pressure, massive workloads, significant backlog. Analysts were expected to process large volumes of exhibits. Defense says mistakes occur in that environment. The investigating officer acknowledged that pressure and backlog exist, but that doesn't mean that you push quantity over quality. Mistakes happen across the lab. The defense referred to a quality assurance review. Approximately 39 files were reviewed. Numerous files allegedly failed quality review. Defense says report deficiencies were not unique only to their client, Makgotloe. Unfortunately, Makgotloe is the only one that was arrested. The others that they're talking about, we don't know them. The existence of errors does not automatically prove criminal conduct. That's their defense.
At the laboratory commissioners, we've got two types of errors. We've got allow me to refer to these commissioners because it was not available at the time of. It is not an annex because it was not available at the time of doing the statement. We've got a critical and non-critical errors. So, if I may explain to you, Counsel, non-critical errors includes is 4 categories. Is incorrect dates on an affidavit, defects or H results not confirmed, administrative errors, and log numbers. Those are non-critical errors. And I will believe that those errors that the council is leading me with falls within this category. So it cannot be incompetence or deliberate. What is the other one?
Negligence.
Negligence.
Working from home is normal. State relies on reports found at Makgotloe's residence when they did the search and seizure. The defense challenged this by asking the investigator if he does take work home, and the investigating officer said he does. So defense says possession of work-related documents at home is not unusual. The thing is, we need to go through all these documents that he had at home to find out for sure if there were current cases that he was working on. I'm sure the investigating officers are working on it. They'll get back to us. He says the omissions were not deliberate. This is the core defense proposition. Counsel directly put to the investigating officer, the omissions were not intentional. The distortions were not deliberate. The issues arose from the work process. The investigating officer rejected that proposition, but it was formally put by the defense. Forensic limitations exist. The defense explored serial number restoration, firearm examination techniques, situations where forensic recovery is unsuccessful. Defense suggests that not every failure to identify a feature or linkage amounts to misconduct. The other experts were given targets. One of the more interesting defense points appears later. Defense instructions put to the witness were: when the Amazimtoti in Durban analyst was asked to conduct comparisons, specific cast numbers had been identified for comparison. Defense appears to suggest that the other analysts in Gqeberha and Durban were not working blind it may have been directed towards a particular case. They will have to prove that. This goes directly to the state's reliance on the later Durban Rebecca findings. This is a career police officer, SAPS member, experienced ballistic analyst, my left foot. Experienced when he is busy pushing quantity over quality. No previous convictions, no outstanding warrants, no violent criminal history. Defense used these factors to support bail. You know what? His crimes are in Schedule 1, so he is likely to get bail. I think he is going to get bail. That's my prediction because it's just Schedule 1. So no proof of corruption, although not stated in one sentence. The defense strategy throughout cross-examination was that there are no payments. He says, where are the bribes? Where is the communication with suspects? Where is the agreement? Defense repeatedly attacks the state's attempt to infer intent from report errors alone. Well, I think the state will have to bring more than paperwork here, paper trails. They'll have to do more digging. Now that they have his phone, maybe they'll be able to find something there. So clearly, this case, the defense question, where is the proof that the omissions were deliberate on the reports, the linkages, and the intent? The state question, on the other hand, is where the omissions, mistakes, or a plan. And this case will be centered around this one thing. Are these errors or was it manipulation? See you on the next one.